welcome back to ATL Lawyers Supreme Court Docket Explained. Today on our first episode, we'll be discussing the Title VII cases that were recently argued during the October 2019 Supreme Court term. So what is Title VII, a lot of you may ask? You hear about it in the news or you read about it online and you're not quite sure what it is. So it is a statute under Title VII of the Civil Rights Act of 1964, and it's a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. And it generally applies to employers with 15 or more employees, including all state, federal, and local governments. So essentially, if you have any of these protected characteristics, then you qualify for protection under this law. Today we're discussing the three cases that were argued in front of the Supreme Court last term, and all those cases, the claims were brought on the basis that the employer had discriminated based on sex. So the first of the three cases we're discussing today is Bostic versus Clayton County. And the facts of this case involve an employee of Clayton County, Mr. Bostic, who was a gay man who worked for the county almost 10 years. He started his employment with them in 2003. And in 2013, while still employed at the county, he joined a gay softball league. After joining this league, however, employees that worked with him began to make comments about his sexual orientation and his participation in the league. And quite curiously, an audit was conducted of the projects he was working on, and they allegedly found financial discrepancies in the audit, and he was then terminated for conduct unbecoming of an employee of the county. Mr. Bostic subsequently filed suit, alleging that his employer, Clayton County, had discriminated against him on the basis of sex because he claims he was fired because he was a gay man, thus claiming that the sex under the definition under Title VII included sexual orientation. This case arises in the 11th Circuit in Georgia, and there's prior precedent in the circuit that says that sexual orientation is not a protected class under Title VII of the Civil Rights Act. The district court, relying on this prior precedent in the Court of Appeals, said, sorry, Mr. Bostic, you don't have a claim here because sexual orientation is not included under the definition of sex under Title VII. Mr. Bostic and his attorneys appealed up to the 11th Circuit Court of Appeals. The 11th Circuit Court of Appeals, hearing the case and the arguments from both sides, decided that they can't go against their own precedent. The precedent in the circuit already said that it's not included in the definition of sex under Title VII, and therefore they upheld the district court's ruling that he does not have a cognizable claim under Title VII for discrimination on the basis of sex. The case was never heard en banc in front of the 11th Circuit, meaning that only a panel of 3 judges in the 11th Circuit actually heard the case and ruled on it. The entire panel of all the judges on the 11th Circuit Court of Appeals decided not to hear the case. Thus, he appealed the case up to the Supreme Court, where it's pending a decision now. So the second case we'll be discussing today as part of the consolidated group of cases for Title VII pending in front of the Supreme Court is Altitude Express versus Zarda. And that case is coming out of the Second Circuit. And that case involved Mr. Zarda, who was an employee of Altitude Express, and he was a tandem skydiving instructor. So if those of you who are familiar with skydiving, who've been skydiving, know that when you're skydiving in tandem, you're strapped in very close proximity to the instructor who's actually flying down with you and making sure that your chute is properly deployed and that you don't die while you're skydiving if you're an amateur. So I've never personally actually been skydiving, but I've seen the videos of it, so I think you probably have too, so you kind of get what's going on there. Mr. Zarda was openly gay, and he would give this disclaimer to his female clients prior to jumping tandem with them that, hey, he was a gay man, so don't feel uncomfortable with you being strapped to me. I'm basically getting no pleasure out of this, is kind of what he conveyed to them. A couple of years into his employment with Altitude Express, a female customer came forward and said that Mr. Zarda had inappropriately touched her during their dive, and Mr. Zarda was subsequently fired following that incident. The female client that had complained to Altitude Express said that yes, Mr. Zarda had disclosed his sexual orientation to her, but he was using that as an excuse so that he could touch her inappropriately. And it is on this basis that the Altitude Express management fired Mr. Zarda. Mr. Zarda then files suit in federal court in the Second Circuit alleging that his employer had discriminated against him on the basis of sex under Title VII. The district court denied the claim and said he did not have one because under prior precedent in the Second Circuit, sexual orientation is not a protected class that is protected under the definition of sex under Title VII. Mr. Zarda appealed to the Second Circuit Court of Appeals, and the Second Circuit panel on the Court of Appeals agreed with the district court and said, sorry, Mr. Zarda, but you don't have a cognizable claim under Title VII. Sexual orientation is not a protected class based on this circuit's prior precedent. Mr. Zarda then appealed for an en banc decision of the Second Circuit Court of Appeals. And what is an en banc decision? An en banc decision is essentially all the judges that serve on the Court of Appeals for that circuit will hear the case at once. So instead of a 3-judge panel that in most circuits would hear the case on appeal, every judge that sits on that Court of Appeals circuit would then hear the case and decide the case. So in a hearing en banc on the issues in Mr. Zarda's case, the Circuit Court of Appeals for the Second Circuit agreed with Mr. Zarda and said, yes, sexual orientation would be a protected class under Title VII, and therefore he can make a claim against his employer for discrimination. The third case in the trio of Title VII cases that's pending currently in front of the Supreme Court is R.G. and J.R. Harris Funeral Homes, Inc. versus the EEOC. And that case actually involves a transgendered woman who had been working at a funeral home as a man for about 5 years. And about 5 years into her employment, she's now a woman, Amy Stevens. Ms. Stevens informed her employers that she was going to undergo transition from a man to a woman surgically. And prior to doing so, however, she was going to live as a woman and dress as a woman during her employment and in her everyday life. Now, the funeral home had a very strict dress code for men and women, and men had to dress a certain way and women had to dress a certain way. And when they were informed by Ms. Stevens that he at the time was going to be doing this, they said, we're sorry, but you can't do that. We're a funeral home. Our clients are in grieving. They're going to be confused if they see a man dressed up in women's clothing walking around the funeral home. And therefore, they fired Ms. Stevens from her job there. Ms. Stevens filed a claim with the EEOC Commission. The EEOC Commission decided that it was a cognizable claim under Title VII as a transgendered woman, and they proceeded with suit against the funeral home. The district court dismissed the claim on the basis of sex under Title VII, stating that sexual identity was not included for the purposes of sex discrimination. However, it did allow the claim to proceed on the theory of gender stereotyping under prior Supreme Court precedent, which we'll discuss in the legal portion of this episode. The district court ruled that the evidence in this case could support a claim for gender stereotyping with respect to the gender-based dress code. They also ruled, however, that under the Religious Freedom Restoration Act, that the owners of this funeral home with their closely held religious beliefs were entitled to an exemption from discrimination under Title VII. And Ms. Stevens then appealed to the Sixth Circuit Court of Appeals. The Sixth Circuit Court of Appeals, however, overturned the district court and said sexual identity is a cognizable claim for discrimination on the basis of sex under Title VII and remanded to proceed under that theory. The funeral home, of course, then appealed to the Supreme Court. With all three cases now appealed to the Supreme Court, there is a split in the circuits as to how Title VII and protections on the basis of sex are applied. So the 11th Circuit, under the Bostic case, had held that under Title VII, sexual orientation is not a protected class under Title VII, and the 2nd Circuit had now held that sexual orientation is a protected characteristic on the basis of sex under Title VII. So there's a split between the circuits, and as we discussed in our preview episode, when there is a split between the circuits, the Supreme Court will usually step in and try to harmonize the application of law with respect to all the circuits. So what are the issues of law that the Supreme Court is actually being asked to consider in these three cases? Well, it's really simple. It boils down to essentially two questions. One is sexual orientation and sexual identity. Are they included in the definition of sex for purposes of discrimination under Title VII? And two, with respect to the Ms. Stevens case and the funeral home case, is there a cognizable claim for gender stereotyping on the basis of sex under Title VII? So with respect to the two questions of law being presented before the court, each side considers pretty much three main points. And I'm going to try and keep those as simple as possible for you when discussing the arguments on both sides. It can get very nuanced. Each side cites tons and tons of precedent to support their positions, but we don't want to get too deep in the weeds. And the point of these episodes are to keep it simple as possible to help you understand the analysis and the legal arguments by both sides in the case. So for these two questions of law, it essentially boils down to three issues on both sides. And the first is, what is the plain meaning of sex and what does that encompass with respect to Title VII? The second point that's argued by both sides is the context and historical statutory construction of the language on the basis of sex. And then the third point that's argued by the parties is the broader statutory interpretation of on the basis of sex under Title VII and what ramifications it could have if it's decided one way or the other in setting future precedent by the court or deferring to Congress and how they should write their laws in the future. So the employees in these cases are arguing that sexual orientation and sexual identity are included within the definition of on the basis of sex under Title VII because you cannot consider a person's sexual orientation without first considering their sex. So in other words, I can't decide if I want to discriminate against you for being a homosexual unless I first consider the fact that you are a man attracted to other men or you are a female attracted to other females. Without this consideration of your sex first, I can't discriminate against you. Thus, it is a natural progression that sexual orientation would be included under discrimination on the basis of sex under Title VII. The employees in these cases are also arguing that you're discriminating on the basis of sex by reason of assembly. So they're arguing that one of the arguments to support their position in these cases is that just because I'm a male doesn't mean I shouldn't be able to associate with other males, or just because I'm a female doesn't mean I shouldn't be able to associate with other females, and whether that be in the sexual context or non-sexual context. So they're arguing that because of my gender, you're discriminating against me because I'm associating with members of the same gender, and therefore, because of that, you're discriminating against me on the basis of sex. So the third theory presented by the plaintiffs in these cases on the basis of sex is that you are gender stereotyping under previous Supreme Court precedent under a case called Price Waterhouse. And what gender stereotyping is when an employer expects a certain man or woman to conform to normal societal gender norms. So women should wear dresses, they should be dainty, they should be ladylike, or men should be strong and rugged. So what the argument on there is the plaintiffs in these cases are saying, you're discriminating against me on the basis of sex because you're expecting me as a man, I have to conform to societal gender norms and I should only be liking women. So they're making the argument that based on the prior Supreme Court precedent in Price Waterhouse, that you're discriminating against me on the basis of sex because I'm not conforming to societal norms and that men should like women and women should like men. So where does the defendants in these cases stand on the issue of what is the definition of sex? Well, predictably, they're relying on the plain definition of the word sex. They argue that in 1964, the dictionary was clear, sex meant gender, and that meant man or woman, and that by defining discrimination on the basis of sex, it meant I discriminate against you as a man, or I'm discriminating against you because you're a woman. The defense in these cases argues that the act of engaging sexually with a member of the same gender is different than the actual characteristic of you being a man or a woman. So while the statute is designed to protect discrimination because you're a man or because you're a woman, because those are specific character traits of a person, like someone's religion or their national origin, it is not meant to protect a person's behavior, such as engaging in sexual acts of members of the same gender. And in support of their argument, the employers in these cases cite numerous statutes from various jurisdictions and various other federal laws which specifically list out sexual orientation as a trait that's protected. So they say, hey, look, if Congress is intending to protect sexual orientation and is listing it as a separate protected characteristic and protected class, then they should do the same here by amending Title VII to make sure it's added and protected. So again, you have the same argument of it's not up to the courts to rewrite the statute. Congress should be doing their job and should be amending this statute to include sexual orientation as protected class under Title VII with respect to employment discrimination. As for the association argument, the employers in these cases are arguing that they're not restricting anyone's association with anyone based on their sex. So nowhere in these cases the employees argue that they are saying that you're fired because a man was hanging out with another man or a woman was hanging out with another woman. So with respect to that argument, the employers in these cases are essentially making the point that we're not considering your sex with who you are engaging with outside the office, either men engaging with men or women assembling with women, but rather that is a separate act that you would do outside of any association being engaged with the same gender sexually, and therefore it is not a protected trait or characteristic that the statute seeks to protect. The third point addressed is this gender stereotyping, and the argument by the defense essentially is that there is no gender stereotyping in these cases because there is no stereotype with respect to men or women as to who is more homosexual. The parties agree that homosexuality occurs equally in men and women, so you can't say that the trait, quote unquote, of homosexuality is more prevalent in a man or more prevalent in a woman, or it's expected that men not be homosexuals and women be homosexuals or vice versa. Therefore, they argue that the gender stereotype precedent in Price Waterhouse fails because there is no stereotype with respect to homosexuality that society would expect from either the male gender or female gender. So that's their argument as to why that fails. So the second area that's argued and analyzed by the court in this case by both sides is the statutory history and the context in which the statute is interpreted. So in these cases, the employees who allege they have been discriminated against, they cite to the Pregnancy Act that was added on to the Civil Rights Act to protect the rights of pregnant women in the workplace. And in those cases, the Supreme Court held very broadly that a statute should be interpreted to protect against the greater societal evils that could exist, and you should read the statute and interpret it broadly so that it protects against these things in the future, so that Congress isn't constantly having to go back and rewrite the statute. In response to that ruling, and that was in the 90s, Congress came back and did amend the Civil Rights Act in Title VII and essentially included all those protections that the court had in their ruling. So on that basis, the employees in these cases point out the fact that, hey, look, Congress went and adopted all the reasoning of the court in that case. Therefore, it should be argued and should be adopted by this court that seeing Congress's actions, that they're going to go back and adopt the broad interpretation of the statute earlier in these cases, that they would do the same if the court were to rule for us in this case. So that's their argument in terms of the statutory history and construction. Conversely, the employers in these cases would argue the exact opposite, and they say, hey, look, reciting their argument again, it's up to Congress to step in and pass a new law or amend the Title VII to make it clear what protected characteristics are included under Title VII, and if they want to, they can amend it to add sexual orientation as a protected class. They also argue that sexual orientation is not dependent on a person's gender. You can either be male or female. Therefore, it is not based on the trait of what gender a person is, but rather it's an act committed by either gender. Therefore, it should not be included as a subset of the definition of sex with respect to Title VII and discrimination against employees. Also in support of their argument in this, the second point, the employers say that the cases that are cited by the employees in support of their broader contextual interpretation by the courts, they again point out the fact that all the cases cited involve discrimination on the basis of gender. So I'm not paying you because you're a man, or I'm not doing this because you're a woman. So they make a clear distinction of the fact that in all the cases that they're citing to support their argument, all of those involved clear lines where it involved the actual gender, male or female, not sexual orientation. So finally, the third argument that's presented by each side is the consistency and interpretation of the broader statute going forward. So the employees, in their argument, essentially cite precedent and case law to support their position of the fact that if the court doesn't take action and make a clear rule by stating that sexual orientation is included from discrimination on the basis of sex, then there's going to be a patchwork of court decisions of lower courts and courts of appeals, and this issue is just going to come back to the court unless Congress steps in or the court steps in, because the courts are not going to have any guidance with respect to where do you draw the line of discriminating against someone on the basis of their sexual orientation or discriminating someone on the basis of their gender, male or female. So they're arguing it's going to be very hard going forward for the courts to make that distinction, and courts are going to kind of weigh the facts and evidence differently as to whether or not this person was discriminated against on their basis of sex or on their basis of sexual orientation if the Supreme Court doesn't step in and give some guidance. So basically they're saying that if the Supreme Court doesn't step in and say that sexual orientation is included as a subset of the definition of sex under Title VII, there's going to be this patchwork and confusing analysis of lower courts and courts of appeals as to whether the discrimination occurred because of someone's gender or because of their sexual orientation if you don't include it as a subset under the definition of sex. Conversely, the employers in these cases are arguing that Congress, again, needs to step in and amend Title VII in order to clarify as to whether or not sexual orientation is protected by the statute. They also state that there won't be any confusion with respect to courts deciding whether or not discrimination has occurred with respect to an employee on the basis of sex or sexual orientation, because the Supreme Court should be able to give guidance to those lower courts as to what is the dividing line of discriminating against someone on the basis of sex under Title VII or discriminating against them on the basis of an act or the act of engaging sexually with someone of the same gender, sexual orientation, or sexual identity. They state that they would agree with the plaintiffs to that extent. However, the court can easily give guidance as to what the line is and where it should be drawn so that there shouldn't be any confusion. So that's their counter argument to the employees' arguments in these cases. And of course, they drive home the fact that they believe Congress should be the one amending this law. It should not be up to the courts to rewrite the law to include more subsections of what constitutes sex under Title VII. So those are the three major points that are argued by each side of the case and their positions on those. There, again, as I stated earlier, there's a lot of case law and prior precedent from the various circuits and Supreme Court that's cited by both parties as to why their positions are correct. We won't get into all those details, but I did want to summarize for you the core arguments of each and why they took those positions and why they think the law supports their position. So with respect to my opinion, how the court's going to rule in this case, I think actually the sexual identity, the transgender argument is a better argument because you are essentially saying I'm being discriminated because I may be a transgendered man or woman, but that is my actual sex that I'm arguing. So if you are going to discriminate me based on my sexual identity, I think it's pretty clear cut. I think what even the defense would argue in these cases that you would be discriminating against them on some basis of someone's sex because they identify as a man or a woman, and therefore if you did discriminate against them because of that, that is the basis of sex. with respect to sexual orientation, we kind of presented the main points on either side as to why their position is correct. So I'll let you debate that and argue that, or you can ask questions or make comments below to this video. So how will the court rule in this case? I think it's going to be a 5-4 decision with Roberts writing the majority in favor of the employees in this case, that discrimination did occur and that sexual orientation and sexual identity is included with respect to discrimination on the basis of sex under Title VII. And I say this because I think the court knows and Roberts knows that Congress is just not going to take action to amend this Title VII statute, especially in an election year. And I think there is remedies that need to take place here. And I think Roberts recognizes this. And now with Kennedy gone, I think he's the swing vote on the court. If it were to be a 6-3 decision, I think Kavanaugh would be joining in with the majority, or at least concurring with the majority. If it was a 6-3 decision, that would leave Gorsuch, who's an originalist, Thomas at Alito, I think, in the dissent, if it was 6-3. But I think it's going to be 5-4. Feel free to make your predictions in the comments if you'd like. So with that, that's the Title VII cases. Hope you enjoyed the summary. If you have any questions or comments, again, you can post them below and I'll try and get back with you. But I look forward to the next episode with you, and take care.